rise. Court's now in session. Honorable Elizabeth Shear presiding. Be seated and remain quiet, please.
Okay, we're here on the case of the state of Florida versus Nikolas Cruz. Are all of the attorneys present?
Yes, Your Honor. Wendy Mandel on behalf of the state, Your Honor.
Liz McNeil, I'm sorry.
Sherry Tate on behalf of the state.
Liz McNeil is also present. The defendant is also present, is that correct? Mr. Cruz is present, Liz McNeil on his behalf.
Diane Cunningham, Mr. Cruz.
Right, let me start off by saying that, although I didn't consider any of these matters to be confidential, an order has been entered on Friday by Judge Robolo. I have reviewed these materials thoroughly, and they deal solely with the public defender's office having access to their own client's person while in the Broward County Jail. I don't believe that the state has suffered any prejudice by these matters being kept confidential, and I am going to leave everything the way it is, with the caveat that in the future, going forward, all matters in this case are going to be heard by this court, and if there is a motion to keep something confidential, the motion, at the very least, is going to be heard by this court in the presence of all of the lawyers and the defendant. Does anyone have any questions?
Judge, are you keeping those orders under seal?
An order has already been entered. Again, I believe I made it clear on Friday that I didn't feel it should be confidential, and I said it for today. But what's done is done. Again, it deals solely with the public defender's access or the defense's access to their own client's person, which, had the state been noticed, I don't think the state would have had any objection or any standing to object to them accessing their own client. Because the issue is so very limited, as far as I can tell, I'm going to leave it the way it is. And just, again, I have a copy of the administrative order for each of you, so that you know in the future, the matters are going to be heard by this court in Division FJ.
Judge, the only issue is that the state, pursuant to the case law as well as the rules, believe that whatever motions were filed by the defense should be accessible to both the state and to all parties. It is part of a court proceeding. I have found some case law that's directly on point that the defense is not entitled to conduct any type of discovery in secret. They did make a request, which was granted at magistrate court, to have access to their client for purposes of photographing him. The magistrate judge had no problem, but it is the state's position that whatever the court is in possession of as way as motions should be unsealed. Now, if you want the state to file a written motion unsealing it, we can certainly do that, but we are prepared today to argue why it should not be under seal.
I don't disagree with you. However, I just feel that because an order has already been issued by this court, meaning a judge in the 17th Circuit, that and because, like I said, it's a very limited issue. I believe the defense was entitled to what they were asking for, and this court has already ordered that the motions and the order be sealed. I'm going to just leave it the way it is.
Okay, we'll file the appropriate
All right.
paperwork. Thank you.
Ms. McNeil, did you want to say anything else?
Nothing at this time.
All right, thank you.
Ma'am, have a seat.
Your Honor, would you be able to prepare a written order for this letter?
Sure, thank you.
Thank you. No, we're not having any comments.